things progress, how the court comes out and moves on the particular matter before them right now in terms of the objections that have been raised.
Well, the statements one of the justices raised are already made when the petitioner was about to respond to the second respondent's addressing his argument, and the justice said that, well, the law is in their bosom. Tell us how powerful the judges of the Supreme Court are in determining cases and how they can also interpret laws. Just briefly on that one.
The Supreme Court is the highest law, highest court of the land. The Constitution establishes a judiciary and vests judicial power in the Supreme Court and establishes the superior courts of judicature, but the Supreme Court at the apex. Then you have the Courts of Appeal, the High Courts, as well as any other lower courts that are established. The Supreme Court is at the apex in terms of justice administration in Ghana. So, and the Supreme Court under the Constitution has original jurisdiction in interpreting and enforcing the Constitution. And so that's what kind of judicial authority and power that is vested in the Supreme Court. And obviously, the power vested in the Supreme Court is dispensed, or justice is dispensed with by the justices of the Supreme Court that are empaneled at any particular point in time to deal with any issue that comes before them. And what the Supreme Court says the law is, that is what the law is. So, for instance, in interpretation, for instance, Parliament can enact legislation that says one thing, but the Supreme Court, given that there's a live case before it, which is not necessarily news, which touches on the validity or the act in its entirety, or some parts of the act as being unconstitutional or not, the Supreme Court can interpret that particular act or provisions therein in a manner that probably wasn't what Parliament was even thinking. That is the sort of power that is given to the Supreme Court within the scheme of separation of powers. We know that the Parliament or the legislature makes laws, but they making the law doesn't mean they interpret the law. Of course, sometimes consideration can be had of the Hansard and some of the deliberations that went on in making that particular law, as well as the memorandum to the law, what probably defect that existed in the existence, what gaps existed in the law that necessitated the enactment of new legislation. But the court, ultimately, the Supreme Court, for instance, if a matter involving that particular act or provisions therein comes before it, can interpret the law in the way that they deem best in terms of giving effect to the essence of the law. So that's why we hear of modern purposive approach to interpretation, where you thoroughly stick to the ordinary meaning of the words, but look at the meaning of the words within the context. If the meaning of the words in the statute, for instance, within the context is plain and clear, there's no need for further elaboration, then it stays that way. But if it would lead to some form of absurdity, for instance, if there will be some absurdity in interpreting the words to mean as they said, the plain meaning of the words, then the court will go beyond that and try to understand the purpose for which the law was enacted and give the law a purposive interpretation to achieve the overall ends of justice. And we've seen it a number of times in numerous cases that have come before the Supreme Court, where the court has adopted the modern purposive approach to interpretation and all that.
All right, just a quick one. This is my final question, then we can wrap up with you while we wait for the justices. Well, we'll take our viewers back to the Supreme Court to join my colleague Abdul Haimun. Just my final question. You said that what the Supreme Court said the law is what the law is. So does it actually matter if a lawyer goes to the Supreme Court to argue his or her case out?
Of course it matters. I mean, it's incumbent on you to persuade the court on your position. So that's why sometimes the mandatory authority, the persuasive authority, and all those things. You're making your case that on the basis of the law, on the basis of precedent and all that, you believe that this is the position of the law, and if that is the position of the law, then your claims need to be validated, for instance, or the relief that you're seeking ought to be granted. it's the opponent or the person, the other party on the other side will also have their argument, will also make their argument that we rather believe that this is the position of the law, this is what we feel the law says and means, and so the court should accept our arguments in support. And obviously, when you're not making the arguments in the vacuum that I believe or you think that the law has to be this way, so it should be that way. No, it has to be grounded in authority. It has to be grounded in case law. For instance, you need to point to statutory provisions or constitutional provisions and then make arguments by trying to persuade the court in terms of your perspective or your opinion, but it still has to be grounded in law. So at the end of the day, the court will, on the basis of everything that is before them, on the basis of all the arguments that the various parties are making, come to a conclusion or a determination that indeed this is what the law says and this is what the law is. And the Supreme Court being the final arbiter of all disputes within our territorial jurisdiction and being the highest court of the land, the court, once it decides, once it gives its judgment, that is what the law says. It doesn't matter that individual parliamentarians or parliament as a whole felt that they wanted to achieve this particular end. But the court, if it, for instance, adopts a purposive approach to interpretation, they can interpret the law to achieve the purpose for which they believe the law was enacted. And that is the essence of separation of powers. That is the essence of having government and giving each its power or its realm within which it operates.
All right. Well, we'll leave here and we'll get back to you. I'll take our viewers back to the Supreme Court, not into the court, but to join Abdul Hai Mumin to pick other reports from there. Stay with us. Over to Abdul Hai Mumin. Led by the lead counsel for the petitioner, Mr. Asiedu Nketia, to present his witness statement. Soon after presenting the witness statement, even before any question could be directed at Mr. Asiedu Nketia, the lead counsel for the second respondent, Mr. Akoto Ampaw, rose to raise some objections to portions of the witness statement as was presented by Mr. Asiedu Nketia. Some of these included paragraphs 6 and 7, which Mr. Akoto Ampaw said were completely out of place in the evidence in chief. And then he also talked about portions of paragraph 25 of the witness statement, asking that it also be struck out from that statement. He spoke about paragraph 26, which also refers to some familial relationship between the second respondent's wife and the chairperson of the EC, among others. And basically that has been what has been going on in court since morning, because counsel for the petitioner, Mr. Asiedu Nketia, also rose to make his points and give evidence as to the fact that these matters that Mr. Akoto Ampaw wanted to be struck out of the witness statement, because according to him these were completely out of place, were indeed tendered long ago in the petition itself, and therefore should be made to stay. The court has risen to consider these matters. So we can report to you that Mr. Asiedu Nketia, the witness for the petitioner, is in the box, but he's yet to respond to any questions this morning, because some issues regarding paragraphs in the witness statements have yet to be resolved. My colleague, who has been sitting in the courtroom throughout the morning, is here with me, Edward Nyapo. So, Edward, thank you very much. We've seen that Mr. Johnson Asiedu Nketia was invited into the witness box. He indeed did present his statement. Soon after that, Mr. Akoto Ampaw rose to raise objections to portions of the witness statement. The judges asked him why he would not wait and do that during cross-examination, and his response was that it might be used against them later in the process if they do not raise the objections at the time that they did. You said in court exactly what happened.
Yes, the issue referred to Mr. Akoto Ampaw, my memory serves me right here, cited Hammond and Odoi case 1982, 1983 in the Ghana law book to justify the reason why he stood up to object to some of the issues raised in the witness statement, and then went on to indicate that some of the issues raised are prejudicial, unduly scandalous, and were not part of the pleadings of the petitioner, and therefore he's praying the court to strike it out. And so these are some of the things that, as we know, the first respondent counsel, Mr. Jasamenuvo, indicated that he associated himself the objections raised by Mr. Akoto Ampaw. Then Mr. Chatrikata, who is the counsel for the petitioner, rose up and also buttressed his argument on the fact that all the things that have been raised there are very cogent and must be are admissible, because Mr. Akoto Ampaw indicated they were not admissible before the court. And so he was urging the court to also ensure that what is captured in the witness statement of Mr. Asiedu Nketia are admitted in court for the process to continue. Let's not also forget that there was some back and forth. We saw some of the argument put forward by Mr. Akoto Ampaw. The judges were asking him some of the issues raised in rules that govern high courts. And one of the judges, I remember, said that there's a new evidence act that is governing these particular proceedings. And to them, some of the judges are not privy, lawyers have not privy to that, and so they keep on going back and forth. It's been very hectic this morning and interesting, and again, we've seen that, as I would say, our democracy is being tested, and once the brains are at work to see to the validity or one way or the other of the elections, let's see how it goes. But let's also not forget that some of the judges also raised issue about some of the issues in the witness statement, and they indicated that some of them were not captured in the pleadings. For instance, the collation of the figures as was captured in the witness statement. They said it was not, and then there was the issue of CI 127, which governs the process of the elections, that in the pleadings of the petitioner, they did not challenge that. But Mr. Chatrikata referred to Article 296 of the Constitution, that yes, did not do that, but to him there were level of biasness, fairness and transparency was not exhibited by the first respondent.
Let's focus a little on the paragraph 26, which refers to the supposed familial relationship between the chairperson of the EC and the wife of the second respondent, in this case, President Akufo-Addo. What justification did the petitioner give for including this in paragraph 26?
Yes, Mr. Chatrikata, I remember very well that he talked about the biasness that was exhibited and the cooking up of figures, and said it has been demonstrated over and over that also contributed toward that. But some judges raised the issue that Mr. Akoto Ampaw said he was making an inference, and some of the judges also said he was making an inference, but he said that no, he's not making an inference, and what he's saying, it was if you look at their pleadings, the witness statement,
that he could present facts to support that argument. Yes.
So he should be allowed to stay within the context of the witness statement of Mr. Asiedu Nketia. So all these things are some of the reasons why I believe that the judges have gone to their chambers, and they will soon come out and let us know what exactly are going to be admissible or those are going to be admissible.
But again, Edward, there was that little, very negligible incident where during Mr. Chachukata's submissions, lawyer for the second respondent got up and interjected, and his submission at the point was that the legal counsel, the counsel for the petitioner, Mr. Chachukata, had spent more than 20 minutes repeating the same point over and over again. Mr. Chachukata did not take kindly to those comments. He described it as disrespectful, and indeed the judges appeared to have supported him on that occasion.
They indicated that if one is an objection, must be, the timing is very crucial. So they use the word timing. He must time it. Mr. Akoto Ampaw also said that he thought he did that. The judges, I remember that was the Chief Justice himself indicating that timing is very important. I don't know if it disrupts the argument of the person on the floor.
All right, we'll leave it here for now as we wait for the judges to return with their verdict. And now, so again, just to summarize it, the verdict we're waiting for is in respect of what in particular?
That are objections that have been raised against some portions. We talked about, we started with page 21, went to 5 and 6, and then came to 25, 26. And then 31. So these are the issues that have been raised. Talking about biasness, talking about unfairness, and all those things. And some through the second respondent, these issues are prejudicial and duly scandalous, and therefore should be not be entertained by the court, admissible in court. So they are going to go through that and come out to tell us what portions of the witness statement are going to be admissible, and those are not going to be admissible for proceedings to continue.
In essence, what we're waiting for at the moment is for the judges to return with their decision, the decision that will be based on whether or not they will agree to the objections raised by a lawyer for the second respondent, Mr. Akoto Ampaw. We'll hand you back to the studio and where the discussions will continue. We'll certainly return when we have more updates for you.
For tabia meko yasaya bawa bobo anubiem na afeidie ye de tabia hand sanitizer e na abewo obai pa ubetimi abon ho ban efri mowa ye fa ye ni enhunu ho na eku 99.99% germs. Tabia hand sanitizer ye the essential oils ene nyoma ebeboa wo honam nkoa na ye. Tabia hand sanitizer e ma wo mfaso na esandroa wo nipadua.
Hey, sanitizer and alcohol ye 80%.
This advertisement has been vetted and approved by the FDA.
In Ghana, the environmental speed limit of 30 kilometers per hour should be observed in residential, educational and commercial areas because human activity is dominant. 50 kilometers per hour is for built-up areas and communities along the highway. 90 kilometers per hour is for the highway. The Accra-Tema motorway has a speed limit of 100 kilometers per hour. Where there are no speed limit signs, the national and environmental speed limits apply. So if you are driving near a school with no speed limit sign, your speed should be below 30 kilometers per hour, so you can stop your vehicle if you need to. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
This advertisement has been vetted and approved by the FDA.
Ganabam, if your your waist, all your body, you make basa.
Today he has been extra sweet, and the way he looks on me.
I have done everything by the book. It's on. Hey, we have to get some condoms, Charlie. Using a condom will protect you and your partner from HIV, STIs, and unplanned pregnancy. Condoms are an effective way for protection against HIV infection. Don't take risks. Use a condom every time. Always come prepared.
This advert is brought to you by the Ghana AIDS Commission, Ghana Health Service, Planned Parenthood Association of Ghana, and the Adventist Development and Relief Agency, with funding from the Global Fund.
When you need a shoulder to cry, one of my campaigns, so we try was suicide. That I won't be back. I guess you want to buy a book, yeah, go straight to start. I'm gonna take you to that level. Baby, oh yeah, yeah, yeah. We're gonna see next level. Baby, oh yeah, yeah, yeah. Take you to that level. Baby, oh yeah, yeah, yeah.
I don't go that level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
It is a nightmare dealing with the filth in Accra. The gutters are choked with garbage. The streets are a jumble of filth. The beauty of the serene beaches is marred with human feces and plastics, as many defecate in the open. Residents are up in arms when the situation gets out of hand.
Most of these meetings, you can't even stand there for even a minute. As you speak there. If it was even refuse to bleed on it.
Partners in sanitation suggest alternative policy interventions.
Landfilling is not the way forward. We are recommending treatment facilities.
But in all of this, have we made gains in the sector?
How can you have people who have a lot of dignity and still practicing
the task facing Ghana to achieve SDG Goal 6 on clean water and sanitation for all is Herculean and riddled with equally complicated hurdles. Join us every Thursday on Wash Hour from 4:05 p.m. to 5 p.m. as we seek to put these issues and more in perspective. Watch a repeat on Fridays from 1 to 2 p.m. and on Sundays 9:30 p.m. to 10:30 p.m. It is our duty to keep our surroundings clean and free from disease.
Welcome back, and our coverage of the 2020 election petition, that's the presidential election petition, is live on Ghana Television, that's GTV. We're also live on GBC News. We are live on radio, that's in Accra. It's unique 95.7, and across the 16 regions of this country, there are various regional and community radio stations. We're also live on Facebook, Ghana Broadcasting Corporation. The internet is gbcghanaonline.com. As of now, we're still waiting for the justices to return from their recession with the ruling on the objections raised by the second respondent with regards to the witnessed statements that have been allowed in by the first petitioner, by the petitioner himself. So the witness statement is made up of 42 paragraphs. Yes, 42 paragraphs. And the second respondent, that is lawyer Akoto Ampaw, who is representing the second respondent, raised objections to 10 of those paragraphs. Whilst we wait for the justices to return with the ruling on that, we'll take you through what's really in these 10 paragraphs and the issues raised. The second respondent, lawyer Akoto Ampaw, raised these objections based on two grounds. The first one is that they did not plead for it, that the petitioners did not plead for these statements that they put in their witness statement, so there's no need of them putting it in there. And the second ground is that it is prejudicial and also scandalous. So based on these 2 points, that's how come the second respondent's lawyer, Akoto Ampaw, raised the objection to this 10 paragraphs out of the 42 paragraphs that is made up of the witness statement of Johnson Asiedu Nketia, who is the General Secretary of the NDC. Let's go through some of these paragraphs. The first one was on paragraph 21. It says that following that the results being published by the first respondent on its website, and gives the website of the Electoral Commission, www.ec.gov.gh, become moving target. First respondent subsequently deleted the changing figures from its website. Then the second respondent moved all the way up to paragraph 6 and 7. And paragraph 6 and 7, first 6 of the witness statement, says that petitioner has accused, has caused to be filed a request to admit facts directed at the first respondent. I'm informed by the petitioner's lawyer that as at the time I am signing this witness statement, a first respondent has not responded to the request. I'm advised by counsel and rarely believe that the response of first respondents or lack thereof to the request of the admitted fact is likely to require a further witness statement from me. And lawyers for the petitioners also applied for leave to serve interrogatories on the first respondents. The court dismissed the application, and an application for review of the second decision is currently pending, should the court allow any of such interrogatories to be served. Response provided may also be relevant evidence which may require a further witness statement. And if you recall, during the arguments for this one, there was quite an interesting argument coming from the second respondent's lawyer, and also another interesting one also coming from the petitioner's lawyer, which also got the justices involved in this particular 2 paragraphs, that is 6 and 7. We move to paragraph 25, which is one of the issues raised by the second respondent's lawyer, which is an objection to that. And paragraph 25 of the witness statement of Johnson Asiedu Nketia reads, this was clearly contrary to the responsibilities the chairperson of the first respondent and the first respondent as a whole had by virtue of Article 23 of the Constitution, which provides that, quote, administrative bodies and administrative officials shall act fairly and responsibly and comply with the requirements imposed by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress and therefore before a court or other tribunal, unquote. In fact, the ever-changing figures put out in the unsigned press release and what was posted on the website of the first respondent in respect of the declaration of the presidential election betrayed a determination on the part of Mrs. Jane Adukwei-Mensah as a returning officer for the presidential election, and certain officials of the first respondent to have second respondent installed as president of Ghana on the 7th of January 2021 by hook or by crook. And this is an issue that the second respondent's lawyer had problem with, specifically with this bit of it, by hook or by crook. From the 25, we move to paragraph 26, which the second respondent, in raising an objection to this, said that it is scandalous. And he said it's scandalous based on what is written. There's a chairperson of the first respondent and the second first respondent are also not required under Article 296 of the Constitution to be biased, either by resentment, prejudice, or personal dislike, unquote, in exercising any discretionary power, but they are required to exercise such powers, quote, in accordance with due process of law, unquote. The chairperson of the first respondent, Mrs. Jane Adukwei-Mensah, allowed herself to be biased by prejudice in favor of second respondent who appointed her in August 2018, and with whose wife Mrs. Jane Adukwei-Mensah has a close familiar relationship. Mrs. Mensah was thus at all material times in the conduct of her responsibilities biased by prejudice in favor of the second respondent and against the petitioner. And again, the second respondent had issues with this bit of it, and they described it as being very scandalous and prejudiced. Then we move to paragraph 28. Paragraph 28, another objection raised on paragraph 28, and on paragraph 28 they had issues with this part of the paragraph where it reads that the secrecy and lack of transparency regarding the figures thrown up by one or more officials of the first respondent seeking to justify after the event. Mrs. Jane Adukwei-Mensah's 9th December 2020 purported declaration undermines the whole attempt at, quote, correction, unquote, of what was indicated an error reading declaration, and shows that the figures were simply being cooked to achieve a predetermined outcome that had nothing to do with actual votes cast in the presidential election for the various candidates. That's just a paragraph 28. They raise other issues concerning paragraph 30, 32, 33, and 37. We'll quickly take you back to the Supreme Court. The justices are about taking their seat for the ruling. Stay with us. We'll be right back.
The first and second respondents have raised objections to parts of the witness statement of Mr. Asiedu Nketia, who has been sworn in as PW1. The objections to those paragraphs, precisely paragraphs 21, 6, 7, 25, 26, 28, 30, and 32, 33, and 37. Both counsel based their objections to the paragraphs in the witness statement of PW1 on two grounds. A, that some of the paragraphs under attack are not based on the pleadings on record. B, some of the statements are unduly scandalous and prejudicial. It would be preferable to set out the paragraphs in the witness statement which in our view are amenable to be struck out from the witness statement. We are of the opinion that paragraphs 6 and 7 ought to be struck out as the witness, Mr. Asiedu Nketia, cannot testify on the facts in the said paragraph. It would have been admissible if the petitioner is himself testifying. The statements in the said paragraphs are not within the knowledge of the witness. We find paragraph 21 as a matter which has its foundation in the pleadings and same is accordingly maintained. As regards paragraph 25, we found that parts that is the sentence beginning with, quote, in fact, the ever-changing figures, end of quote, to the end of that paragraph is hereby struck out as not based on the pleadings. In respect of paragraph 26, the court is of the opinion that the statement from line 5 above, beginning with, quote, the chairperson of the first respondent, end of quote, to the end of the paragraph is struck out on the basis that it has no foundation in the pleadings. As regards paragraph 28, from line 6, that is the sentence beginning from, quote, the secrecy and the lack of transparency to the end, end of quote, to the end is not borne out of the pleadings, and we accordingly struck it out. In respect of paragraph 30, the court is of the view that it has no foundation in the pleadings, as it just refers to CI 127, which the witness cannot testify on the statute. As regards paragraph 32 and 33, we found that they are based on the pleadings and therefore ought to be part of the witness statement, and they are accordingly maintained. In respect of paragraph 37 of the witness statement, we found that it is just an inference to be drawn and not evidence. We therefore proceed to strike it out. The court therefore orders the paragraphs referred to as offending the law are hereby expunged from the witness statement of PW1.
My lords, we are most grateful.
We are most grateful to the court. As the court pleases, and just for the sake of clarity, I would like to understand what was said in respect of paragraph 30, paragraph 30, because the reference to the regulations in CI 127, that's in the first sentence, but the rest of the paragraph, including the exhibit C, is not related.
Yeah, the whole of paragraph 30.
The whole is
the whole of paragraph.
Yes. That's the whole of paragraph 30. Now, 20 December 7 election and the rules passed by Parliament, is that correct? The 20 elections were passed, was conducted by rules passed by Parliament, is that correct?
That's correct, my lord. It is supposed to be conducted by the rules. But we have issues about the application of the rules in the conduct of the elections.
CI 127 is binding on the petition. Well, yes, it was expanded. Sorry. The petitioner appointed agents for each of the polling stations in the country. Is that correct?
That's correct, my lord.
How many agents did the petitioner appoint for each polling station?
2 agents.
Now, at each polling station, the petitioner and indeed all the other candidates had agents. Is that correct?
I cannot speak for candidates.
Now, you trained your agents on what their duties at the polling stations will be.
Yes, my lord, that's correct.
You trained your agents on how forms 8A and 8B was to be completed in each of the polling stations.
That's correct, my lord.
You trained your agents on how each form was self-auditing and designed to reduce errors and mistakes. Is that correct?
That's correct, my lord.
You also train them that at any point that they had a problem with what was happening at the polling station, they could refuse to sign the form but state the reasons for it. Is that correct?
That's correct, my lord.
You also train them that if they stated the reasons for not signing, the issue will be taken up at the constituency collation centers. Is that correct?
That's correct, my lord.
You also train your agents that at the end of counting and entering of figures, they collect their copies of the Form 8, whether or not they signed it. Is that correct?
That's correct, my lord.
You also appointed agents for each of the 275 constituency collation centers. Is that correct?
That's correct, my lord.
You train them that unresolved issues from polling stations will be noted on Form 8B for resolution at the constituency collation centers. Is that correct?
That's correct, my lord.
You also train them to expect to receive the duplicates of the Form 8Bs that have been given to them at the polling stations. Is that correct?
That's correct, my lord.
Now, you also train them to cross-check their Form 8Bs with anything that is done at the constituency collation center. Is that correct?
That's correct, my lord.
You also train them that from all the information on Form 8B, the EC officials will collate the results onto Form 9. Is that correct?
That's correct, my lord.
You train them that after collating on Form 9, the results will be entered on Form 10. Is that correct?
That's correct, my lord. But all with the involvement of our agents.
Now, you also train them that if they have any issues with Form 10, they could refuse to sign it and say the reasons therefore. Is that correct?
That's correct.
Now, you also train them that once the Form 10s were completed, they were entitled to their copies.
That's correct, my lord.
So it is right to assume that your agents had all the Form 10s with them. Is that correct?
Come again, my lord.
I'm saying that it is right to assume that based on your answers, your agents had the Form 10s with them.
Yes, my lord, it could be assumed.
Yes.
Now, whether that is the case is another matter.
Now, you also agree with me that with our elections, results are declared at all the polling stations before they move on to the constituency. Once the results are counted, they are declared at the polling station before we move on to the constituency centers.
Yes, my lord, unless there is a challenge about a particular polling station results.
Yes. And at the constituency level, the collated results are put together and then a winner of a particular constituency is declared. Is that correct?
We have two elections at the constituency that are collated at the constituency level. I don't know which one. Is that the presidential or parliamentary?
Sir, you are here because of the presidential elections.
Okay, yeah.
My question is in reference to the presidential election.
The declaration is not done at the constituency level. They indicate the tally for each candidate. The presidential election results are declared at the national level by the returning officer.
Are you therefore saying that at the constituency level, your agents do not know who has this number of valid votes at the constituency level?
That's what I'm calling the tally. The tally of the votes are known. But that is not a declaration of the presidential election.
Okay, good. You train your agents that the Form 10s will be transmitted to the regional coalition centers. Is that correct?
That's correct, my lord.
Now you also appointed agents to each regional coalition center. Is that correct?
That's correct, my lord.
Indeed, some of your agents, as announced publicly, were lawyers. Is that correct?
That's correct, my lord.
Now, you also trained your agents that all the information on Form 10s will be collated into Form 11. Is that correct?
That's correct, my lord.
You also trained them that from collating the results on Form 11, the results will be entered on Form 12. Is that correct?
That's correct, my lord.
Now, you also trained them that at that point, they would be invited to either sign onto the Form 12 or object. Is that correct?
That's correct, but they are involved, so they are not sitting somewhere only to be invited to sign. They are involved in the coalition, and if they agree that the process has been proper, they are invited to sign.
Okay. Now, are you aware that of the 16 regional coalition forms, your agents signed 13 of them?
Yes, my lord.
Are you also aware that one of such forms that was signed was in reference to the Ashanti region? Is that correct? One of the forms that your agent signed. It was in reference to the Ashanti region.
Yes, my lord.
Your agent signed the form for Ahafu. Is that correct?
That's correct, my lord.
Your agent signed the form for Oti. Is that correct?
That's correct, my lord.
Your agent signed the form for Northeast. Is that correct?
That's correct, my lord.
Your agent signed the form for Bono. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper West. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper East. Is that correct?
That's correct, my lord.
Your agent signed the form for Central Region. Is that correct?
That's correct, my lord.
Your agent signed the form for Western. Is that correct?
That's correct, my lord.
Your agent signed the form for Savannah. Is that correct?
That's correct, my lord.
Your agent signed the form for Volta. Is that correct?
That's correct, my lord.
And your agent signed the form for Bono East. Is that correct? Bono East.
Bono East.
It was signed by Ali Mohammed Samsudin.
That's correct, my lord.
Good. Now, on each of those forms, your agent signed to declare as follows. Quote, we the undersigned do hereby declare that the results shown above are true and accurate account of the ballots in the region. Is that correct?
That's correct.
Now, at the National Coalition Center, which is the headquarters of the first respondent, you appointed 2 persons to that place for the coalition. Is that correct?
That's correct.
One of such persons is Rojo Metonunu. Is that correct?
Yes, my lord.
And Mr. Rojo Metonunu has been a former deputy minister before.
That's correct.
And Mr. Rojo Metonunu has been involved in elections and has even litigated 2 cases in these courts. Is that correct?
My lord, I can't testify to the fact about his litigations, but I know he has been involved in our elections.
Now, there's a reported case. Right. Now, are you aware that at the National Collation Center, Mr. Rodo Metonunu certified 12 of the 13 forms signed by your representatives?
My Lord, I cannot testify or deny, but the other agent who will be present in court to testify as to what happened in the National Collation Center.
Right. Now, let us go to your witness statement. You spoke about Exhibit D, the letter from the National Democratic Congress.
Yes, ma'am.
Dated 9 December 2012. I suggest you that that letter was not delivered to the first respondent.
My Lord, our agent who was in the headquarters of the first respondent will be present in court and will attest to that fact.
So you do not know whether it was submitted or not?
A report was made back to me that it was submitted.
I am putting it to you that that letter was not submitted to the first respondent. Yes. I am putting it to you that that letter was not submitted to the first respondent.
My Lord, that fact will be confirmed or denied by the agent who will be in the box subsequently.
So you are telling this court that you do not have personal knowledge of whether or not the letter was submitted to the first respondent.
My Lord, I indicated that I had a report, a feedback that it had been submitted, and since I wasn't present there, I cannot say it as a matter of something that has come to my knowledge.
Right. Now, let's go to your letter. Your letter is in two parts. Is that correct? You can look at it.
Yeah.
It is marked Exhibit D. Yeah. Would you be kind enough to tell the court the person who signed this letter?
My Lord, it was signed by my deputy on my behalf.
What's the name of the person?
Peter Boama Otokuno.
Right. Now you agree with me that the portion marked C talks about parliamentary elections and therefore has nothing to do with the petition in this court.
Yes, my Lord.
You also agree with me that despite all that you've written about Ashanti, Ashanti was signed by a gentleman called Boja Gemfi. You know him?
Yes, my Lord.
And I'm further putting it to you that Ashanti was signed by, was certified by Mr. Rodo Metonunu.
My Lord, the agents who will come subsequently will be able to confirm that or deny it.
do you know whether Rojo signed or not?
Please, I would like to take the question again.
I'm asking you whether you know that when Ashanti came in, duly signed by Mr. Bujet Rojo Metonunu signed against it. Do you know or you don't know?
My Lord, the document that come to our notice is the final declarations. The signing on the regional declarations at the strong room are not brought to us.
Well, I'm putting it to you that for Ashanti, the form was signed by Buja Dimfi in Ashanti region, and when it was transmitted, and when it was transmitted to the strong room, as you call it, Mr. Rojo Metonunu signed it.
Well, I can't testify or deny because what happens in the strong room is within the knowledge of people who are in the strong room.
Now, you have attached to your letter 2 sheets from the eastern region. Is that correct?
That's correct, my Lord.
On the first sheet, your agent signed the form. Is that correct?
My Lord, there are 2 sheets. I don't know which is first and which is second.
The second one is what you have. There's one that your agent did not sign. If you look at the forms, there's one. The one with the blue ink at the bottom, your agent did not sign.
Yes.
The one that doesn't have the blue ink, your agent signed.
Yes, my Lord.
Right. Now, if you put together all the valid votes assigned to each of the candidates that your agent signed, the total will be 1,196,751, and not the 1,236,940 that was written on the form.
My Lord, I have realized that the totals, yes, I've looked at. Yes, my Lord, that is precisely what I'm about to do. I have done the collations, the additions, and I have realized that the totals on both sheets are the same figures, but the figures that add up to the totals are different. And the one marked in blue is actually accurate.
No, we'll come to the one marked in blue. I am saying that if you add up all the valid votes assigned to all the candidates from number 1 to number 12 on the form that your agent signed, the total should be 1,196,751 and not the 1,236,940 that was written on it.
My Lord, I can confirm that the totals are not the aggregates of the numbers there, but I don't remember the actual figure that I got. If the court will permit me, we can add and find out what it is. Yeah. But all our phones have been taken.
My Lord, my Lord, we brought the calculator.
Yes.
If the court will permit, you can do that.
Yes. Six. Yes, your calculator is not. 1, 2, 9. It's order in court. $1,186,751.
Now, kindly deduct that figure from the figure written on the form. That is 1,236,940. What will you arrive at?
$40,109.
40,000.
109.
189.
189.
So 189. Yeah. Good. Now, look at the last page of your Exhibit E, which is the sheet that you attached to your evidence. Listening. Now, there is a constituency there called Ayenswano. Ayenswano. Do you see 40,189 over there?
Yes, my lord.
I am suggesting to you that the second sheet that your agent did not sign was corrected to include the Ayenswano constituency results.
Well, I cannot testify to that because if there is any correction to be made on any declaration, those who are part of the declaration must be present for the corrections to be made.
Yes, but you also are aware that where the person whom you have appointed to represent you leaves and refuses to be part of the process, those who are there sign on to the form and the process continues. You are aware?
Yes, I'm aware, but
now I am putting it to you that when the Ayenswano results were added, all the candidates got the additional votes that they got in Ayenswano, that's making extra gains to make the total valid votes 1, 2, 3, 6, 9, 40. I am putting it to you.
My Lord, can you come again?
I am putting it to you that when Ayenswano results that I have just shown you, that if you take the difference that you got from the first sheet from what they had written, you get 4189, and that 4189 on your own spreadsheet as it is, it is spread across all the candidates. The only person who didn't get a gain was Hassan Ayarik. I'm saying that if you put it together, the gains that each candidate made in Ayenswano, the total will now come to 1, 2, 3, 6, 9, 40. And I'm putting that to you.
Yes, my Lord.
Good. Now, therefore, I am further putting it to you that the Eastern region sheet had no problem, for which you ought to have written to the first respondent.
I deny that, my Lord.
Now, I am further putting it to you that the 3 remaining constituencies that your agents, the 3 remaining regions that your agents did not sign, the petitioner won those regions.
Lord, if the figures are in contention, we are not able to determine who won.
Now, those regions are Western North, Northern, and Greater Accra. I'm putting it to you that the candidate won at those regions when the coalition was done. That's the petitioner.
My Lord, I repeat that if the figures are in contention, it is difficult to determine who won.
Now, are you therefore saying that with respect to Greater Accra, you do not know that the petitioner won the election?
My Lord, you claim my agents did not sign, which means that the part of our case that the figures are in contention.
You see, I am putting it to you.
And in the presidential elections, regions are not won.
Yes, my Lord. Well, my Lord. Well, my Lord.
In the presidential elections, regions are not won. There is one presidential elections and one returning officer who declares the winner at the national level. No other declaration of the presidential elections take place anywhere else.
Right. Well, I am putting to you that for the record, Western North was won by the petitioner, and the Western North form, although not signed by your representative, it was certified by Mr. Rodo Metromoon in the strong room.
My Lord, the agents in the strong room will mount the witness box and they will be able to testify whether they signed or did not sign.
Do you still stand by your petition in this court? The petition that you filed, do you still stand by all the averments in it?
Yes, my Lord.
Now, let's look at paragraph 12 of your petition. Sorry, the petition of the petitioner, sorry. paragraph 12 of the petition of the petitioner. Kindly read paragraph 12 to the court. Paragraph 12. Yeah, I'm ready. Paragraph 12 of the amended petition, sorry, Lords. Have you seen it? Yes, my Lord. Kindly read it to the court.
If the total number of valid votes standing to the names of each of the presidential candidates is summed up, this will yield a total number of valid votes cast of 13,121, 13,121,101, a figure that is completely missing from the purported declaration. 111, a figure that is completely missing from the purported declaration by Mrs. Jean Adukwe Mensah on 9th December 2020 and the purported ratification on 10th December 2020.
Now, I am putting it to you that the figure in the paragraph 12 of the petitioner's petition shows clearly that the number mentioned by the first respondent as the total valid votes was an error, which you have admitted in your petition.
Can I hear the question again, please?
I am putting it to you that as at the time you filed this petition, you knew that the figure 13,121,111 was the correct total valid votes that ought to have been announced on the 9th, as you have said in the petition. I'm putting it to you.
My Lord, these are figures we computed from the first respondent's own data that was supplied. These are not our figures.
Well, you are bound by your petition, so let's go on. At the point that the declaration was going to be done, you have stated that your agents, Mr. Metulunu and Dr. Pesa White, left the strong room. Is that correct?
That's correct.
I am putting it to you that they left the strong room because they realized that the petitioner had lost the election.
Well, I can't attest or deny that one, and these are matters in the personal knowledge of the agents who will be mounting the witness box subsequently.
And they left the strong room because they didn't want to sign the Form 13.
I can't attest to that.
And I'm putting it to you that the total valid votes as at the 9th of December 2020 and captured on Form 13 is just the same as the total valid votes in the form in paragraph 12 of the petition.
My Lord, we don't know which is the total valid votes as we stand here, because the first respondent has churned out several different figures. So our case is that Ghana does not know the results of the presidential elections as we sit here now. Because the petitioner who has the constitutional duty to conduct the elections has not, the first respondent who has the constitutional duty to conduct the elections and report an exact figures has failed in that duty. So we are confronted with several figures and it depends on what you want to believe.
Are you saying that you do not believe in the figure that you wrote in your petition?
I picked, my lord, I stated that we picked these figures from the respondent's own calculations, not ours. We haven't supplied.
And I am putting it to you that if your representatives had not left the strong room, you would have seen that those figures, 13, 121, 111, was the total valid votes as captured from 13.
My lord, I can't respond on behalf of the agents. I have indicated that one of them will be in the witness box to testify.
I am further putting it to you that 8 out of the 12 presidential candidates stayed back and signed on the Form 13.
My lord, I have indicated that the processes within that National Coalition Center are not within my personal knowledge, and so I cannot answer, I cannot admit or deny.
Now, at the time the petitioner filed this petition, he knew the results from the Teaching and South constituency, not so?
My lord, I'm not the petitioner.
Okay, we'll leave it.
Now, let me refer you to your form, your Exhibit E. Look at under Bunu East. Bunu East. Yeah. Do you see the valid votes that the petitioner obtained?
As per the computation of the first respondent, yes. Because these are not our figures, they are figures from the first respondent.
You also agree with me that the petitioner never obtained all the 128,000 registered voters' votes from the Techiman South constituency as you purport to show in your evidence. I'm putting it to you.
Well, there's nowhere in the evidence that you propose to say that the petitioner was all. Respectfully, there's nowhere in the evidence where the witness says that the petitioner got all the registered votes in Techiman. There's nowhere in the evidence to that effect. And I think this is just to kind of mislead the witness.
Yes, my lords. My lords, I am not, with the greatest respect, misleading the witness. Lords, as at the date that the witness filed his witness statement on the he signed his witness statement on the 27th of January 2021, he, in paragraph 12, sought to make analogies with the Techiman South total number of registered voters. And that is why I am asking him genuine questions based on his own documents that he has brought before the court. My objection is very simple. He's made a specific statement that the petitioner, the petition says that all votes in Techiman South were won by the petitioner. There's no way. This talk about by analogy and so on. Let him point to where in the witness statement.
Yeah, Mr. Amenuwo, please.
Yes.
Reframe the question.
Now, yes, my lord.
He raised an objection. What is your response to that? You are reframing the question.
Lord, I'll rephrase the question.
Okay.
Right.
And then tell me that.
Now, as at the time you filed this petition, I am suggesting, as at the time you filed your witness statement, I am suggesting to you that you could not include paragraph 12 because the total valid votes that the petitioner had obtained were known. I'm putting it to you. And the Techiman South constituency, they were known.
As at the time you were filing the witness statement?
Yes, they were known.
Yes.
Good. I'm further putting it to you, therefore, that as at the time that the petitioner filed the petition, all the total valid votes in Techiman South were known.
On behalf of the petitioner.
So I am putting it to you.
Yes.
That using all the total valid votes in the Techiman South constituency, that's registered voters in the Techiman South constituency, to do your analysis is incorrect. I am putting that to you.
My Lord, the analysis was based on what the first respondent herself claims. So all the information there, all the figures that were stated there were from the first respondent's own account when they were declaring the results. And if I may proceed, the first respondent claimed that even though they have not had the results of the Techiman South, they feel secure to proceed because even if all the votes of the Techiman South were to be added to the petitioner's tally, it will not change the outcome. Yes. So the analysis we did there was to show that based on the figures she herself declared, that statement could not be correct.
I am putting it to you that the first respondent's chairperson was right, because as at the time she was making the declaration, you knew that the total valid votes in the elections was 13,121,111. I'm putting it to you.
My Lord, I don't understand the question. That I knew, or the chairperson who was doing the declaration knew.
You,
because I didn't do declarations.
You, as the witness in this book, you knew about that. I'm putting it to you.
That when the first respondent was making the declaration on the 9th, that I knew that the total figures, total of the votes was 30,121,111.
Yes, because you stated to, the petitioner stated to in his petition that ought to be the correct number, and the first respondent in her answer agreed with you. So I'm putting it to you that you knew.
My Lord,
answer the question.
I don't understand why you seem to be confusing me with the petitioner. Because I don't understand.
You see, that's why we have to strike out some of the evidence. Because you can't speak to them. And so that's the basis upon which we have to strike out some of the evidence. We are confirming our position.
Oh. Well, I'm still waiting for the answer.
I'm saying that I cannot answer for the petitioner. You're asking me questions that ought to be asked to the petitioner. And now I'm saying that I'm not. So, I took these figures from the respondent's declaration. Now, and before they were declared, I couldn't have known what he was declaring.
The figures at the time. Now, can you read paragraph 13 of your witness statement to this court?
My Lord, paragraph 13 of my witness statement. When the percentages of valid votes cast and standing to the names of each of the presidential candidates on my witness statement, okay. Witness statement. Are you taking? You're taking the witness statement. It's here. Paragraph 13. Yeah, paragraph 13. The Techimansa constituency has a total registered voter population of 128,018. And if added to the total valid votes announced by Mrs. Jane Adukwe Mensah as cast, which is 13,434,574, the resultant figure would now be 13,562,592. Consequently, if all the votes of Techimansa constituency were added to petitioner's votes, second respondent vote will remain the same as 6,730,413, now yielding 49.625%, while the votes of petitioner will increase to 6,342,907, now yielding 46.768%.
So I'm putting it to you that you knew the results from the Techima South, and therefore this analysis of yours is incorrect.
My Lord, I beg your permission to quote paragraph 12 of my statement. That will explain the meaning.
Please answer the question and then you can explain.
Okay.
Answer the question. I'm saying that at the time you were making the statement,
yeah,
you knew the exact results of of the Techiman South constituency, and therefore the analysis that you had made was wrongful. Answer the question, yes or no. If you want to explain, you explain.
The analysis was right because it was based on a statement made by the first respondent at a certain point in time. So if you are analyzing that statement at that point, I don't see how you bring in the current situation to be able to answer that statement.
I suggest to you that you are wrong because the current situation is the reality. The court deals with reality, not conjecture. I'm suggesting that to you.
My Lord, the current situation cannot be the reality because nobody knows the results of the presidential elections in 2020. Nobody knows in exactitude how many votes each of the candidates got and what percentage each of the candidates got. And the first petitioner, the first respondent, in her own words, and my Lord, I beg to quote in my own statement, currently, the election results we have declared exclude that of Techiman South constituency, with a voter population of 128,018. The said election results are not ready because they are being contested. Even if we were to add the 128,018 full results to the results of the second candidate, it will not change the outcome of the election. Hence our declaration of the 2020 presidential results without that of Techiman. The respondent was justifying why she had to declare results based on uncompleted tally. And we are questioning that statement, that statement could not have been correct as at the time it was being made.
I am putting it to you that as at the time the first respondent chairperson made that statement, the statement was correct and it is captured in paragraph 12 of the petitioner's petition.
I decline that.
Very well. Now, what was the source from which you obtained information to draw up your Exhibit E for this honorable court?
My Lord, Exhibit E was based on the first respondent's own data.
But you have gracefully brought it to the attention of the court. You want to rely on it, is that not so?
Yes, want to rely on it to the extent that we want to prove a case against the first respondent.
No.
I'm a teacher, my Lord.
Now, my lords, in Exhibit E, there are votes assigned to the petitioner and the second respondent and all the other presidential candidates. Is that not so? That's on the last page of Exhibit.
By the first respondent, yes.
Now, what we have here is 677-6066 for the second respondent. Is that correct?
From where, please?
That's the total. Yeah, the total valid votes. Yeah. Is that correct?
6,776,066.
That's what is on it. Is that correct?
I don't know. Yes, it's in this statement.
Yes. And then also for the petitioner, we have 6,265,276. Is that correct?
According to this document submitted by the first respondent.
No. It is your document we are looking at, please. Now, look below the figures we have just gone through. For the second respondent, there's a percentage of 5.126. It is down there. That's 51.126. Sorry, 51.261. The way we have rendered it, that's why.
0.51.
Yes. 0.51261471. Is that correct?
That's correct.
Now, I am suggesting to you that this works to a percentage of 51.2614.
Percentage of what?
A percentage of the total valid votes also on this sheet.
It's 51.263%.
That is correct. Yeah. Right. Now, for the petitioner, we have 47.397 assigned to him by your sheet. Is that correct?
47.397. Yes.
Right. That's correct. Now, deduct the number assigned to the second respondent. No, deduct the number assigned to the petitioner from that assigned to the second respondent and tell this court the difference.
Which of the numbers? You asked about percentage.
6.
You are now asking
6, 7. Yes, I've moved on from percentage. 677,6066 minus 6265,276. What do you get?
677. As it's not that good, I think you'll be stretching the witness about 510,790.
Thank you. Thank you very much.
Okay.
Yes. You got 510,790.
Yes, my lord.
Right. Now, it is not true that the first respondent padded any votes as you allege. I am putting it to you.
My lord, I decline that assertion.
Now, in your exhibit F, you allege that 4693 votes was added in favor of the second respondent. That is the allegation.
My Lord, if you look at my statement, I indicated that I'll bring a sample of the constituencies and polling stations where pardon took place. I did not indicate that that is an exhaustive list of all the places where the pardon took place.
Sir, we are using the numbers that you have brought to the court to assist the court. I am saying that the total of 4693 is what you have put down there. Is that correct?
I brought it as a sample. I did it in my statement, actually indicate that this is from a sample of this particular constituency. I don't understand sample to mean total of the population.
Now, deduct the 510,790, you deduct the 4693 from 510,790. What do you get?
With all due respect, I don't see the point of the...
With the greatest respect, you are being rude to the court, not to me.
Okay. Yeah, come again.
I'm saying that deduct 4693 from 510,790. What do you get?
Please. I got 506097.
Good. I am suggesting to you that even if this your number as alleged, which is denied, even if it is deducted from the total value votes of the second respondent, he still has won by your own sheet by 51.246%. I am putting it to you.
My Lord, I deny that because that you are subtracting apples from mangoes. But this is a sample. You want to take a sample from a population of another group. But I don't see where the calculation is coming from.
You see, I am suggesting to you that you have no evidence to support your allegation, and that is why you have brought only what you have. I am putting it to you.
My Lord, we are not in court to try to declare another presidential results by us. We are in court to challenge the performance of a constitutional duty of a first respondent and to see whether that duty has been discharged faithfully.
If that is so, then I'm suggesting to you that you are not, by your own showing, you are not in the right forum.
I decline that, my Lord.
Now, you had earlier told this court that you cannot speak to what happened in the strong room when your two representatives were there.
Yeah.
Is that correct?
That's correct.
My Lord, on that basis, I'll end my cross-examination of the witness.
Yes, my Lord, I do. So, Mr. Asiedu Nketia, you recall that before the declaration of 9th January 2021, 9th December 2021, so relax. 9th December 2020, your party and your presidential candidate
held a series of press conferences on what you consider to be the outcome of the elections. Is that not so?
It is so, my lord.
And in those press conferences, you announced to the whole world that the petitioner had won the presidential elections and was, by the votes you had collated, the president-elect. Am I correct?
My lord, that is not in my witness statement.
So can you answer that question? You did say so, didn't you? Come again. I said your party, including your good self and the first petitioner, and also one Otokuno, your deputy, together with other leading members of your party, you held several press in court. So I'm putting it to you that your party held a number of press conferences.
Yes, my lord, that is so.
Now, in those press conferences, or in some of them, you were present and you spoke on the issue of the results of the presidential elections.
Yes, my lord.
The petitioner himself also spoke on the outcome of the presidential elections.
Yes, my lord.
And your deputy, Tokuno, equally spoke on the results of the presidential elections.
My lord, I can attest to my statement at a forum where the petitioner was present and he spoke. But I don't remember being present at a forum where my deputy spoke.
Now, you know that your presidential candidate, that is a petitioner, asserted that he had won the 2020 presidential elections.
My lord,
Ghanaians had voted for change.
My lord, what I remember the petitioner said was that the results as declared by the first respondent is not accurate.
Now, I'm also putting it to you that you yourself declared that the petitioner had won the presidential elections.
My lord, unless I'm reminded, but I remember saying that NDC has won parliamentary majority in parliament, and that will give President Mahama a comfortable situation to be able to run the next government.
So I'm suggesting to you that by that statement, you were saying that the petitioner had won the elections and was going to become the president.
My Lord, there were all indications that he was going to become the president.
Not indications. I'm saying that by what you said, you meant that he had won the elections because that was the only way he could form the next government.
My Lord, if I meant that, I would have said so.
Mr. Asiedu Nketia, we served on the petitioner our witness statement.
Yeah.
You are aware?
My Lord, I'm not the petitioner.
I didn't say you are the petitioner. I said we served on the petitioner our witness statement.
Yes, I'm aware he has been served.
Have you seen a copy of the witness statement?
Yes, I've seen it.
Do you admit that in the witness statement of the petitioner, of the second respondent, we have attached Exhibit 6.
Exhibit
6.
This one.
Hours, we are looking for hours. Yes, can you answer?
Yes, I've seen this in the brown envelope.
So we presume that you know the contents. So we presume that you are speaking, you know the contents of that video clip.
Well, my Lord, I have not played the contents, so I cannot testify that I know what is contained in there.
My Lord, I would need some direction here. This is a problem that arises at trial in the High Court. Our witness is not at the moment giving testimony. The witness on the other side is giving testimony, and you want to confront him with material or exhibits in your witness statement. In our witness statement, to discredit him. What he's saying. Now, at the time that he would have finished his evidence and stepped out, when we leave that evidence, he will not be available to respond to the content of that evidence. play the video so that we will exactly. Yes, my Lord. Very well. Yes.
Mr. Akoto Ampaw.
Yes, my Lord.
You are conducting your case, so if at a point you think that there is evidence which you want to make an application to the court to allow you to either show to the court, you have to put that application before the court. And as it is, you have not made any application. We have to give the other side the opportunity to respond. What you're asking is you want directions from us.
Yes.
So you know what to do.
My Lord, may I, with your leave, make an oral application to have the video that we attach to our witness statement played out, so that we can properly confront the witness with his own acts and that of the petitioner, together with leading members of his party, on the issue whether or not they declared to the Ghanaian public that petitioner had won the election.
You have to address us on relevance. So what is the relevance? What would this video establish?
The relevance is that the petitioner and his supporters or his leadership led Ghanaians to believe that they have won the election and that there was an attempt by the first respondent, together with, in collision with the second respondent, were trying the will of the people, and that they had all the necessary page sheets to demonstrate that they had won the elections. When they came to court finally, after a lot of pressure from the public that if you won't come to court, all they're saying is that if you use the errors in the chairperson of the first respondent's announcement, then neither party has won, so there should be a remand. It goes to their good faith and credibility.
But Mr. Akoto Ampaw, anybody at all can call a press conference and declare himself or herself to be the winner of an election. And you mean because I called a press conference and declared that I won an election, that should be taken as the law?
No.
We have laws, we have regulations, and how we know how to declare our results.
My lords, where a major party in the republic, like the NDC, is mobilizing its...
Mr. Akoto, you see, the witness is denying these allegations. Yes. That is why you have your witness statement together with this, would I say, proposed exhibit or whatever, served on him. If it is your time, or if your time comes, then you have to put in. Yes.
My lords, what I'm seeking to, I'm actually applying to the court for leave to play the video and use it, because it's part of our case, and use it to cross-examine the witness. And my lord, I'm saying that this is a difficulty.
You are talking about credibility. You want to establish credibility.
Yes.
Yes, so you haven't said so.
No, my lord, I said it goes to his credibility. I said so.
You have to premise your application in the rules, and you have to premise your application in the rules of court and in the Evidence Act. That's your job. That's your burden.
Well, I mean, our application is relevant to this petition to the extent that it demonstrates the credibility of the petitioner in respect the credibility or lack thereof of the petitioner in respect of the 2020 presidential elections. And yes.
So what is your submission? What is your submission? What is the application that you want us to?
My application is for leave for the
view confronting with the exhibit.
Yes.
Okay.
Because it's very invasive, almost to the point of denial.
The challenge we have is that you did not give any indication prior to this hearing that you want a video to be played.
My lords, it's attached to our witness statement that I believe all your lordships have copies of, and I have every reason to presume that you know that we like to play it.
I'm not sure whether the registry, Mr. Registrar, I'm not sure whether there is any provision made for that. Do you have? Yeah.
I always take an advantage. My lord, I respectfully, we have not been heard. There have been several steps. We have not been heard even in respect of basic attempt. Okay.